Hello, this is Judge Johnson in McHenry County Circuit Court, part of the 22nd Judicial Circuit here in Illinois. Oftentimes what I find is that folks who come for a trial who are self-represented don't really know what to expect. And so today I'd like to talk to you about the process or the order of events in a bench trial in traffic court. First, I begin with preliminary matters. Sometimes a motion is made when I ask for preliminary matters. One such motion that is often made is a motion to exclude witnesses. And what that motion essentially asks for is that anyone other than a party to the case who is going to testify in that case be excluded from the courtroom while other testimony is being heard. That motion is sometimes made in an effort to prevent anyone from being biased or prejudiced by the testimony that they are hearing from other people in the case. Sometimes no motions are made during preliminary matters, but I will always ask. After preliminary matters, opening statements proceed. Now, an opening statement is a statement of what you expect the evidence to show. It's not evidence itself. You might think of it as a preview for the court about what the court is about to hear or what you hope to prove through the evidence you have prepared. You're not required to give any opening statement, but you'll have the opportunity. After opening statements, I will open the evidence. The prosecution has the burden of proof, and therefore they will go first. I'll turn to the prosecutor and ask if they have a witness to call. Usually, they do call a witness first. I swear that witness in, and then the prosecutor begins asking questions. Once the prosecutor is done questioning that witness, I'll turn to the defendant and ask you if you have any questions for that same witness. That's called cross-examination. You can ask questions at that time. Please put them in question form. Isn't it true that? Who, what, when, where? For instance, question form. Once the prosecutor is done calling witnesses and attempting to introduce evidence, at some point they will rest their case. And at that point, I'll turn to the defendant and ask you how you want to proceed. You're not required to do anything at all, but you might choose to testify or call witnesses or proceed in some other way. If you do want to testify, I'll swear you in to tell the truth, and you'll have the opportunity to share with me the facts as you believe them to be from your point of view. Once you've done that, if you've chosen to testify, the prosecutor will have the opportunity to cross-examine you, just like you cross-examined the prosecutor's witnesses. If you have other witnesses to call, please make the court aware of that so that we can get those witnesses into the courtroom if necessary and swear those witnesses in. At some point, you'll be done presenting evidence and you will rest your case. At that point, all the evidence is in, and I'll ask for closing arguments. Closing arguments are a persuasive statement from each party about why they believe the case ought to be decided in a certain way and what the evidence has shown to the court. Generally, from the prosecution, I hear why there has, for instance, been a violation of the Illinois Vehicle Code. And from the defendant, I hear why there has been no violation of the Illinois Vehicle Code. I'm hopefully in a position where I can make a decision after I hear all of that evidence and after I've also heard closing arguments if you want to provide one. I'll provide you my decision, try to explain to you why I reached that decision. Please know that I will not reach any decision until I hear all of the evidence in the case. Thank you.